Welcome to PLMA Live, the online video program that brings you face-to-face with people making news of importance to store brands. I'm your host, Tim Simmons. It's been 3 months since Procter & Gamble filed a lawsuit in U.S. District Court claiming that a major retailer's private label mouthwash looks too much like a competitive P&G product. While the outcome of the case may not be known for some time, the legal action points to the long-standing importance of trade dress in the sales and marketing of store brands. And trade dress involves almost all aspects of product development, package design, and labeling. To get a better understanding of trade dress, we're talking today with our legal guru, PLMA General Counsel Arthur Handler. Arthur, welcome to PLMA Live. Let's start with the basics. What exactly is trade dress?
Trade dress, as the name implies, is the dress of a product, but it doesn't simply include the outside configuration or appearance of the product, but it also includes all aspects of the packaging and labeling.
Arthur, why is the law concerned with trade dress?
It has a very, very definitive purpose in the law, and it's a purpose which many people don't appreciate. Trade dress is basically designed to identify the source of the product which is in question. So it is not like a copyright, it is not like a design patent in which the embodiment is owned by an individual. Trade dress is simply a source identifier.
Arthur, you say that most people don't understand that trade dress is intended to identify the source of a product. Are there any other misconceptions?
I think the biggest misconception of trade dress is the fact that if a dress looks like another dress, there's something wrong. The truth of the matter is that with trade dress can be imitated, so long as the imitation does not create confusion as to source. And there's very good reasons for that. Number one, you don't want the dominant manufacturer to be able to foreclose competition in the marketplace by appropriating and owning a bunch of roses as a trade dress, or the color red or the color yellow on a particular product. So you're concerned, and the law is concerned, with anti-competitive foreclosure in the marketplace through the misuse or the expansive use of trade dress enforcement.
Well, from what you're saying, it sounds like the courts believe that trade dress can really help shoppers.
The consumer is making, particularly in a supermarket situation, consumers walking down an aisle and making instantaneous decisions. What better way to serve the consumer's interests than to enable the consumer to know or understand what the function and category of the product is? So trade dress serves this informational purpose.
Arthur, what are the rules for trademark infringement?
You can't go to a fixed body of rules and look at 6 rules and say this trade dress infringes or that trade dress does not infringe. It's a question of reviewing many, many different cases, analyzing the facts of each case, and then applying the substantial likelihood of confusion rule.
Is it ever fair to use a competitor's registered trademark on your own product?
Yes, it is, but subject to very, very stringent rules. For example, it is quite common for a store brand product to put a compare to legend on its product and encourage the consumer to compare the private label product to the branded product. In doing so, the private label dress can and does often refer to the branded product's trademark. However, it must be accurately and completely disclosed that trademark is owned by the branded product, so that there's no substantial likelihood of confusion that you're trying to pass off your private label product for the branded product.
As I mentioned before, the big national brand companies like Procter & Gamble are aggressively filing trade dress suits against their private label competitors. What's behind that?
Store brands and private label brands have made substantial inroads in the marketplace and various channels of distribution. And it's my view that the branded products are very concerned about the increasing competition that they're facing in the marketplace. And they are therefore using trade dress as a competitive instrument in order to slow down or attempt to slow down the competition and make packaging and promotion and labeling more difficult for the private label manufacturers. And that really, it's become an economic competitive weapon, in my view.
So Arthur, it looks like trade dress will continue to be an important issue for everyone involved in private label. Arthur Handler will be monitoring trade dress for PLMA and will be updating us on the latest developments. Thanks for watching this edition of PLMA Live, and join us next month for another exclusive interview.